Oh yay, oh yay, oh yay. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated.
Good morning.
Welcome to the Supreme Court of Texas. I'd like to welcome this morning, before we get started, our new Justice, Justice Kyle Hawkins. We're very, very glad to have you with us, Justice Hawkins.
Thank you, Chief.
We'll hear argument in 4 cases this morning. The first is 240286, Studio E Architecture versus Lehmberg from Bexar County and the 4th Court of Appeals. The second case is 250593, consolidated with 230742, Cockrell Investment Partners versus Middle Pecos Groundwater Conservation District from Pecos County and the 8th Court of Appeals. The third case is number 240543, Family Dollar Stores of Texas versus JLMH Investments from Tarrant County and the 2nd Court of Appeals. And finally, 240447, State of Texas against JRJ Pusock Holdings from Harris County and the 14th Court of Appeals. The court has allotted 20 minutes to each side in each of the cases. We'll take a short break between the arguments, which can be viewed live online and will be available on the court's website later today. With that, we're ready for argument in case number 240286, Studio E Architecture versus Lehmberg.
May it please the court, Mr. Alexander will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, this case presents a straightforward legal question. If a complaint filed by a plaintiff has been dismissed without prejudice because it failed to include the requisite certificate of merit, can that defect be cured by filing an amended petition attaching the certificate, or must the plaintiff file a new action attaching the certificate? The respondent takes the former position, we take the latter, and we say that the rule that you have to file a new action should apply whether there's only a single defendant, as in the Levinson Alcozer case, or multiple defendants, as in the Enviro business case that I'll be discussing shortly.
What about in a case where the defendant has waited till the very last minute, which happened here pretty much, to file a motion to dismiss? And let's say that there are no other claims involved that perhaps don't require a certificate of merit. And so, you know, if they don't have time to replead now, and it wasn't apparent on the face that they would need a certificate of merit, even though the trial court disagreed, but there's no time, how would that be fair?
Well, the way that's been addressed actually by this court is to say that it can be waived. In other words, there are circumstances where a party waits too long to, now mind you, back in the text of the statute, there's no affirmative requirement that the defendant flag to the plaintiff you need to timely file.
Well, the statute does say that you're not required to file an answer until 30 days after the filing of the affidavit, which suggests this should all happen pretty early.
No,
before the filing of an answer.
Well, you only have to file answer after the certificate of merit has been filed.
Right.
So let's say that none
and if it hasn't been filed, then you don't have to file an answer, but here you filed an answer.
No, absolutely.
And so that's what I'm saying, is it suggests that all this sorting out of whether a certificate of merit has been filed or not is going to happen while the defendant is thinking about whether to file an answer.
No, and I think that that's largely true. But again, let me address the 2 Supreme Court cases and then this case. So the 2 Supreme Court cases to look at are cross-text, which laid down the rule that you can waive. In that case, the court found that there was no waiver, even though there had been, I think, 11,000 pages of exchanges of discovery. The other case is Lalonde, Lalonde. Subsequently, the court said in that case there was a waiver, because in that case the defendant waited until the eve of trial, had fully participated in discovery, had sought other affirmative relief in the case, and the court said under those circumstances it had been waived. Now, in this case, what you need to look at is Lehmberg 1, where the court specifically addressed the issue of waiver and said that in that case, because the defendant had not actively participated in any depositions, had only responded to discovery, there was no waiver. So the waiver issue was addressed in this case in the prior proceeding. This court denied review.
If the third amended petition had been filed within the limitations period, would your argument be different?
That's a great question, and let me answer it this way. The answer is no. The answer would be the same. In other words,
The case would still be dismissed.
The case would still be dismissed because it was not filed with the first filed petition.
And what
However,
says that it has to be filed with the first filed petition?
it says it has to be filed with the first filed petition.
It
Now,
says file with the complaint. is
that
what-
says filed with a
And of course, we
complaint.
don't have complaints in Texas,
Exactly.
so I'm not sure why it says complaint.
Yeah.
But assuming that means petition, it says with the complaint, not with the first complaint.
But it's been uniformly been interpreted as being with the first complaint. Now,
Why
it can
wouldn't we
be,
treat this as the first complaint and merely a petition and intervention? Because there is no action for it to relate back to. I understand that it was styled third amended petition, but because the prior action had been dismissed, albeit without prejudice, there was no live pleading when this was filed. So why wouldn't it just simply be a petition and intervention?
well, I mean, the way it should be done is if you look under tab 3 of the bench book, what should happen in that situation is if there's been a dismissal, then what the plaintiff must do is to file a new action attaching the certificate of merit, and then have the case consolidated with the original case. That's exactly what happened in the Viro business case.
Why wouldn't we worry more about how limitations applies to the claim, irrespective of the vehicle in which it appears? That seems to really be the more important question.
Well, I think at the end of the day it is. I mean, I think that, but what we have to understand here is, I mean, why should it make a difference? The real difference here is that they are taking the position that because they filed an amended complaint, they've never expressly said that, but you can ask them when they stand up here. They're taking a position that they get the benefit of the relation back doctrine.
But none of
Even
that's
though-
before us, right? Because
I'm
it
sorry?
wasn't, none of those issues are before us because there was no summary judgment motion on limitations. Limitations wasn't raised in the trial court.
Correct.
So all we're here talking about is really not whether it relates back in this posture. I mean, I agree with the chief's, inclination that that's really the important question here is limitations, but that's not before us.
Correct. It's not. And so the question
Doesn't
before this court
your argument
is,
depend and just assume on the idea that there is going to be relation back?
their argument depends upon relation back.
Yes,
they-
and
they-
you seem to agree that that is so, and I'm curious why that is.
That there
Would there be relation back?
There is not. Okay, I mean, and let me be clear about this. Our position is that they don't get the benefit of relation back. Their position is that they do get the benefit of relation back. Our position is, back to your point, the only issue before the court is what is the mechanism by which you can cure the failure to.
But what I didn't answer was the question to Chief Justice, answer to Chief Justice's question, because that's what is really important here.
It's the elephant in the room.
Yes, absolutely. So what is your answer to that?
I mean, the answer is, and let's be clear, because I don't want to overstate our case. I mean, the court technically could say, we're not going to decide anything here. Go find out limitations in the Court of Appeals. You should not do that because we have a cleanly presented question that has befuddled the courts of appeals, and that is, how do you cure a defect? Do you have to file a new action, as we say must be done, as compelled by, if you looked at the Cross case that's under tab 2, if you have a case that's been dismissed, it's as if it was never filed. It's tabula rasa. In that situation, mechanically, the only way that you can reinstitute a claim is not with an amended petition, but a new filed action that's consistent with the text, and that's what's pointed out in the
What
environment.
in the civil rules says that? I mean, the civil rules, the rules of civil procedure generally want you to bring all your claims together, right? If they're relating to the same sort of issue and, dispute, you want all the parties and the issues in the same case because it's just more efficient to do it that way. So, I mean, I understand the limitations issue, and that's great. You can go back and file your motion for summary judgment on limitations and fight about whether this all relates back, but I'm concerned about messing up the doctrine of when you can file amended petitions or petitions in intervention to bring people into the same case because it's efficient to do that.
Well, let me answer it this way. I mean, ordinarily that's true, but we're dealing here with a dismissal without prejudice. And if you go to tab 3 and look at the Cruz versus Morris case, the court says any dismissal order stating it is without prejudice to refile refers to refiling in a new cause of action, not simply filing an amended petition within the same cause.
What in the
So-
civil rules says that?
Nothing. So
Right.
it's not in the civil rules. What you're applying here is I would call it a common law rule and a common sense rule. Because the position, if you go to tab 2 and look at the Crofts case by this court, the court is saying that, it is elementary that a dismissal is not an adjudication of the parties. It merely places the parties in the position that they were in before the court's jurisdiction was invoked, just as if the suit had never been brought. So the practical problem here, and again, I'm back to limitations, is, Cruz tells us that the way that you deal with that situation is to file a new action and consolidate. It is easy to consolidate under the appellate rules. I mean, I will say.
That would be true.
Yeah.
That would make great sense if there had only been one defendant in the original action. But here, where there were multiple defendants, it seems like the opposite of common sense to start a whole new lawsuit when you could just join this defendant in the existing case. And so I'm struggling to hear you articulate why that ought to be the rule. It's certainly an option if you want to waste time and have a motion to consolidate, but just assume with me that you'd go and amend and join the defendant into this case that already exists where there's a common transaction at issue. What does that have to do with relation back? Why does that necessarily impact the statute of limitations analysis at all?
So this court has never addressed that question. So we've cited in footnote 2 of our reply brief, Court of Appeals decision saying that you do not get the benefit of the relation back doctrine if you merely filed an amended pleading. The position that we're taking, they're arguing the opposite. That is to say that you do get the benefit of the relation back doctrine. Again, they've never expressly said that, but to your point, Levinson and Alcozer involved a single defendant. If you look at the Enviro business case by the Dallas Court of Appeals, it is following this court's decision in Crofts. And that case involved 2 defendants. It was a multiple defendant case. The plaintiff felt constrained to file a new action as opposed to merely amend, because that's what this court's decision in Crofts compelled, because it puts the parties in the position as if the suit was never brought. You can't just hop back into a case where we indulge the fiction that there was never a suit filed in which you were a part.
That
you
was
have
a
to
case
start
involving a single defendant, though.
Which?
Crofts?
It may be. Enviro business is not.
Well, but those just seem like 2 separate questions. One is, can you file a petition, an intervention, or an amended petition to bring somebody in to an existing case? Yes or no. And then does it relate back for purposes of limitations? Yes or no. You could very well be right about that, but why should we make a large change to the law of how you do intervention or in cases that don't involve limitations just so that you can win this case?
Because
Two
your argument
answers.
sounds that way, that you
I'm sorry?
want this because you want the case, the limitations to have run. And if that's not the case, what is the case?
Okay, so to be clear, we win on we win either way, okay? Either they have to file a new action in which everyone agrees under Levinson and Alcozer they're time barred, or we say that if you decide not to engage in that, and I don't think it is a big change in the law at all. I think that it's entirely consistent with, for instance, what the Dallas Court of Appeals did in the Buyer Business case. So not a big change. But if you throw us back to say, just go decide on limitations, we say we win. Okay, let's see what they say. But what I'm saying is you can avoid that entire limitations battle, remanding us back by citing the question that's presented here, which I think is absolutely compelled by Crofts, regardless of the fact it had only one defendant.
Could we come back to the word that Justice Busby flagged in the text of the statute, complaint? So I guess two questions. So complaint, it is odd to use it in a Texas court. It's a defined term in Chapter 150 here, and it means any petition or other pleading which for the first time raises a claim against a licensed or registered professional.
Correct.
So would that support your argument that it needs to be with the first filed petition because it's wherever it shows up for the first time?
Yes, and I'll give you an example. There are cases in which you can do it by an amended petition. Let's assume, for example, to your point, that
Yeah, add
you
a
had
new
case-
defendant, now it's a licensed professional, now you need to attach the...
Correct.
But then what do you do with the fact that in 150.002E, instead of, because you're saying that they need to bring a new action, but E says that the failure to file an affidavit, quote, shall result in dismissal of the complaint against the defendant, dismissing the complaint rather than the action.
Correct.
What do
It is the
you do with
complaint.
that?
No, what I do with that is, it is just a complaint. It is not the lawsuit. It is the complaint. The question is, in that posture, that plaintiff at that time, which can't take any benefit at all from the initial suit, because there's been a dismissal without prejudice. That's what Crofts tells us. At that point, what must the plaintiff do? And we say, and I think it's supported by this court's jurisprudence, you must file a new action. And then you simply consolidate, which is, Texas rule, back to Texas Rules of Civil Procedure, 174. Nothing is more simple than a consolidation.
So
I
let
see
me
I'm out of time.
ask, if you're arguing that under the definitions that a complaint is the first filed, then under that theory, even if limitations is not an issue, we're well within whatever limitations period there is, you wouldn't even be able to file a new suit because it's not the first filed, right?
No, you can, it would be considered the first filed suit. In other
Because
words,
it's
if
a
you
new
have not
lawsuit.
attached a certificate of merit, it's dismissed, it's tabula rasa, we're starting anew. You can, at that point, file an action attaching that, and that is the first filed petition.
Any further questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Ms. McFarland will present argument for the respondent.
Mr. Chief Justice, and may it please the court. A Section 150.002 dismissal is a sanction to deter meritless claims and bring them quickly to an end, but it is not a death penalty sanction. The legislature intended to provide claimants a second opportunity to comply with the requirement to file a certificate of merit.
Can I just ask you, what is your response to this argument that I just alluded to, that in the statute, that complaint is defined as the first filed, whatever the word is, document?
I would agree that the courts have interpreted the statute to mean it's the first filed complaint in that action. And so here, what the Fourth Court did was they took the Crofts language saying, once you have a dismissal without prejudice, none of the merits have not been adjudicated, the parties are returned to their pre-suit status. And so then, once the second amended petition was dismissed without prejudice, our third amended petition became the first filed petition in this action.
So you're saying an amendment regardless, even if you didn't have these other claims, that it would be okay because that's taking the place and that is now the first filed?
Correct.
I got you.
The Fourth Court's decision to allow the pleading amendment comports with both the legislative intent of the statute and the goal of deterring meritless claims. as we've heard before, earlier, after waiting more than 2 years to move to dismiss Ms. Lehmberg's claims, Studio E now effectively seeks to impose a death penalty sanction forever barring her claims, and we do not think that result should be permitted.
Can I ask you, how do you square the idea that there would be relation back in this case with the Levinson case, where we said there is no tolling while the appeal is pending?
Right. Well, we don't think we're seeking to relate back here. We've not expressly stated that we're seeking to relate back, but if any, we're relying on Crofts, which is what the Fourth Court relied on, to take us back to our original pre-suit position, at which time we were not barred by limitations, and then we could file our claims against Studio E.
How is that not relation back?
It very well may be a form of relation back, but as the court has noticed, this morning we had several defendants in this case. From a judicial economy standpoint, it doesn't make sense that we would have to institute a brand new lawsuit. And it comports with the legislature's intent to give claimants a second chance to comply with the statute. Subsection E specifically grants discretion to the trial courts to decide whether the dismissal is with or without prejudice. And and that discretion has been interpreted to mean that a plaintiff should be given a second opportunity to comply with the statute. And if we take the petitioner's reading of the statute to mean that we would have to file a new lawsuit, at which time we'd be barred by limitations, we would never get that second opportunity to comply with the statute.
What does your reading make of G, though, where the statute says that this provision isn't intended and should not be read to extend or alter the statute of limitation?
Right. We would argue that we're not tolling statute of limitations. I mean, tolling is a stopping of the clock. Relating back is different, and I think petitioner is trying to conflate the two. And so our argument would be that there is no tolling here.
You mentioned that your friend in opposition waited 2 years to file the motion to dismiss for want of the certificate. Is there, where's the beef on that? Is there any legal principle or anything, some kind of estoppel or anything like that? Or just sharp practice? I
mean, I think petitioner is correct that that was decided in the first appeal. We did argue waiver there. The court said there had not been any efforts made to litigate the case. I would still contend that it seems very unfair for them to lie behind the log for over 2 years. It was over 2 years. And wait until limitations have passed. And I think that that's the danger in crafting a decision that would allow defendants to do that.
But you filed a petition for review, and we took a pass on it at that time.
Correct.
How is it that you filed a third amended petition before the mandate issued from the Fourth Court of Appeals because you had a pending PFR here?
Yeah, as far as I'm aware, there was no stay in place. I mean, the parties just continued to file for continuances. And so as soon as the Fourth Court determined that a certificate of merit was required, we went ahead and amended our pleadings and attached an 8-page affidavit, which has never been challenged as insufficient or inadequate by the Studio E. And that's, was another basis for the Fourth Court's decision, was saying that this decision does not run afoul of the purpose of the statute, which is to deter meritless claims, bring them quickly to an end. I think we can all agree that the statute hasn't worked out to bring things quickly to an end. Here we are, it's been almost a decade. She first filed suit, Ms. Lehmberg, in 2016. And again, as far as meritless claims go, we believed in good faith that an affidavit was not required. Once the Fourth Court determined otherwise, we did amend our petition, added that affidavit from a licensed architect and engineer, and again, there's never been a single complaint that those claims were not meritorious, that they were frivolous, and so we believe that the Fourth Court's decision complies with furthering the purpose of the statute, and also with furthering the legislative intent to give claimants a second opportunity to comply with the statute.
Is there something procedurally dissonant with, or discordant with having the claim be dismissed without prejudice and then filing what's called a third amended petition? Because ordinarily, when we think about that, it's to replace an existing petition, right, when we rename them serially. And in this case, it seems as though it's renamed serially, but there is no live pleading. Why isn't this more like a petition in intervention?
I'm not sure why the trial attorney decided to do it that way. I will say that the pleading amendment was made before the dismissal order was signed. So at that point, I think it was proper to amend the petition.
Could you help me understand the basis for your argument that the statute of limitations defense has been waived?
So, I think we've backed off a little bit from saying outright waiver. I do understand that you can make new arguments in support of your issues. I don't think that they are.
I just mean, just contemplate the idea that you have a remand back to the trial court. Could they raise the statute of limitations as a defense at that time? And I take you to be saying no because it's been waived. I'd like to try to understand how a defense like that has been waived.
I don't think that it's been waived, and it's not been pled in the trial court. It's an affirmative defense, and so Rule 94 says you have to plead and prove affirmative defenses. Their answer does not state statute of limitations. They've never raised it before the trial court. It was not raised before the Court of Appeals. And so it seems a little unfair to now accuse the Court of Appeals of failing to grapple with this limitations issue when it was definitely not put before it.
Yeah, I'm doing no such thing. I'm contemplating a future, situation in the trial court, and I took your argument to mean that they would be barred from raising the defense at some point in the future. I grant you that they haven't raised it yet.
Correct. No, I don't think we were arguing that they would be barred from raising it in the future. I haven't gone down that road. It hasn't been raised yet. Could they amend their pleadings if we go back to the trial court? I assume they could if there's nothing else, a DCO or something that would prohibit them from amending. That would be a new fight.
Understood.
I don't think I saw it in your red brief, but do you want to respond to what do you do with subsection G of 150.002? The statute shall not be construed to extend any applicable period of limitation or repose.
Our argument there is that we are not extending limitations. Crofts took us back to our pre-suit position, at which time we were not barred by limitations. And so, we have not stopped the clock. We're not tolling limitations here. Unlike in Levinson, where the plaintiff expressly pled tolling and knew it needed to in order to get around limitations when it elected to file a non-suit and file a new suit.
So we do that there's a doctrine called American pipe tolling, where if you file a class action and you file it before the limitations period expires and then it's litigated for a while and it ultimately fails, the people who would have been putative members of the class get tolling during that time. They're put back in the position that they're in before the class action petition was filed so that they can file their own independent actions. But do we apply that in any other context? And it seems like that would be tolling. So you said Crofts puts you back in the position you were in before. Help me understand how it does that as to limitations if we're not applying tolling.
Well, if anything, it would be relating back and not tolling.
Why would it relate back?
Well, because we have pending claims and parties on the trial court's docket. It was a multi-defendant case, and so it's the same transaction and occurrence. And so the rules say that you can, Rule 63, you can amend your pleadings at any time. And the Messina court talked about how it was more efficient to allow parties, like in any normal case, to bring in defendants through pleading rather than having to file a new action after dismissal without prejudice.
You mentioned Rule 63. Rule 62 defines amendment in the context of a petition. It says the purpose of amendment is to cure a deficiency. I'm wondering, isn't that what's happening here? And should we consider that rule in deciding this case?
Curing the deficiency would be, where you're trying to come into compliance with the statute by filing a pleading that has a certificate of merit attached to it. So, and we think this would be our first filed petition in this case. I do want to respond to the Cruz case really quickly, and that is the case where petitioner gets a language that says you can only file a new suit. You cannot amend after a dismissal without prejudice. I mean, Cruz is kind of particular. I read it in the special exceptions arena. There, the trial court granted special exceptions and gave the plaintiff 30 days to cure. You can fix your pleadings. You have 30 days to do so. Well, she didn't do it within 30 days. She waited until, I think, day 31, and then she files an amended, and then she files a supplemental later. Her claims are dismissed, and she says, well, wait a second, it was without prejudice. And, there, the thing is, she couldn't circumvent the trial court's order giving her these 30 days by amending. I mean, her time to amend was up. And the two cases that Cruz relies on are Ashpole and Bueller. And, I read those as a little bit different too. In Ashpole, the parties came back to the trial court 12 years after a final order dismissing the case had been signed. And they say, hey, can you seal these records? And the answer is no. It's been 12 years. The entire case had been dismissed. The trial court has lost plenary power, cannot take any further action. You're going to have to either file a new suit or file a motion to reinstate. And in Bueller, also, we had termination of the entire case by dismissal. And the court says this was an effectual dismissal of the plaintiff's case. The case was no longer on the docket. You needed a motion to reinstate to have any further action. And we don't have that here. There was a pending case on the trial court's docket. Multiple parties made sense for the trial court to say, yeah, let's take the pleading amendment and go from here without you having to file a new action and consolidate.
So it was pointed out earlier that Justice Sullivan mentioned that the complaint, being required to file with the complaint, the certificate of merit, it means the first filed petition. And then E said, so that's in 150.002A, and then 150.002E says you can have a dismissal without prejudice, that it may be with prejudice. And so the courts of appeals, you said, have interpreted that to mean that you can refile. Is that because you're harmonizing? So you've got something that says first file, but then you've got something that says without prejudice. And so do they get to that result by saying you've got to harmonize these two parts of the statute, or?
Yeah, I think they get there by saying, I think they look at A, and A says, right, in an action, a claimant has to file with the complaint an affidavit of a licensed professional. And that, whether that is a new action or it's the current action, again, once our second amended petition was dismissed, our third amended petition took the place of that. Operated, as the fourth court said, as our first filed petition in that action.
Because it followed a dismissal without prejudice.
Right.
You'd mentioned kind of what's fair and what's the purpose of the statute. If we could talk just a second about C, it talks about how the statute imposes a contemporaneous filing requirement and then creates like a pretty short window for an exception if you're right up against the statute of limitations. There's not enough, somebody bring me a civil engineer, and then you get a very small window of time when you can file the certificate. So if the legislature has said you've got 30 days to do that, then why wouldn't we treat this contemporaneous filing requirement as a direction from the legislature? Weed these kind of cases out, or get the certificate done like right up front?
Well, I think here, once the fourth court determined that we needed one, we did. I mean, we immediately went and got our affidavit and attached it. And I think C is addressed in, I believe it's the Miramar case out of Corpus. And there, the plaintiff did invoke C when it filed its sixth amended petition once it was determined that a report was needed, an affidavit was needed, because they were, I think, 1 day away from limitations. And then within the 30 days, they got their report filed. And that was a pleading case, an amendment case.
And I apologize that I didn't go back and read your briefs from the first trip up on appeal that you took. Why was it that you made the decision when the first petition was filed not to attach one of these certificates? Why didn't you think one was, I know that the fourth court said otherwise, but why not file one right up front?
Right after the motion to dismiss was filed?
No, no, like with the very first petition that you filed with claims against Studio E.
Gotcha. We did not feel that we did not believe that we were implicating architectural services. We didn't assert a negligence claim against Studio E. And in fact, our second amended petition expressly disclaims any urgence of architectural services as would be read under the statute. And so, yeah, we did not believe that we needed to file one at that time.
How onerous are certificates of merit to obtain?
I would think fairly onerous. I mean, I'm sure that you've got to find I'll say I've never done it. I would assume that you've got to, reach out and find the right professional, give them time to inspect the property or, the building, and time to draft the report. And, I would assume there's an expense that is associated with that the plaintiff has to take up front. And so I think, to your point, unlike Chapter 74, I think there is now a provision that allows plaintiffs to get a preliminary determination as to whether they are implicating a healthcare liability claim and is a report going to be needed. We don't have that in this statute. And so it does put the plaintiff's attorney to a little bit of a burden right up front to decide whether they're going to incur that time and expense.
Do you think you would be prevented from, or that a plaintiff would, from making that request even though it's not set out by statute?
I'm not sure what the mechanism for that would be.
Just a motion with the court.
Yeah, I mean, worth a shot, I guess. Well, if there are no further questions, I will give back the remainder of my time.
Any further questions? Thank you, Ms. McFarling. Mr. Alexander, you have 5 minutes.
Thank you, Your Honor. I'd like to begin by just addressing 3 questions posed by Justice Sullivan, which I think really tee things up.
Sorry.
The first one is, I think that you have teased out here. I mean, everyone agrees that limitations had run when the complaint was filed, the third amendment petition was filed. And they tried to explain how it is that they nonetheless have a live lawsuit. The question you ask is, how is that not relation back? It is relation back. I mean, let's be clear about it. The position they're taking is relation back. They don't have any equitable, totally doctrine they can point to. They're after relation back. Which brings us to the second question that I'd like to address, Justice Sullivan, which was, how does that not run headlong into subsection G, which talks about how no provision shall be construed as extending a period of limitations. Well, it does run into that. So to give effect to the text of the statute, they don't get that benefit. Finally, you ask the question, well, are we really talking about sharp practices here? I want to call the court's attention to one portion of the record, it's clerk's record, page 60, which I think deals with some of the sharp practices issue. So in this case, there was a scheduling order. It called for all dispositive motions to be filed as of January 11, 2019. The motion to dismiss that they're complaining about was filed almost 2 months before. In November, it was November 16, 2018. So plaintiffs can ameliorate this problem by scheduling orders. There's ways to deal with unfairness issues in the trial court. But waiver is now dead. Res judicata. This was addressed in Lehmberg 1. The court properly applied this court's jurisprudence, cross-text and Lalonde, found that there was no waiver, which then brings us back to the basic question here: can you cure a defect merely by filing an amended petition? Back to your question, Justice Settle, it shouldn't make any reasoned difference that the rule should be one way if you've got multiple defendants and a completely different way if you've got only one. I understand that in Levinson there's only one defendant, but it shouldn't make any difference. If you apply Crofts, that once a case has been dismissed, you're back to square one, the way to address that is to treat all plaintiffs the same under the statute and say you have to file a new action, as was done in Levinson Alcozer.
But the rules of civil procedure don't do that. They recognize if you've got a case going on already that there are other ways to bring in a defense.
So how do you accommodate the rules of civil procedure with this statute? You apply Texas Rule of Civil Procedure 174 and say to give effect to this statute, which, and I'm not saying it trumps the rules, but to give effect to this statute, treat everybody the same, you file a new action, and attach your complaint to that. There's nothing onerous about that. The rules of civil procedure accommodate that.
I mean, if just outside of this context, let's say you have a 5-claim case. One claim is dismissed under Rule 91A. The other 4 claims proceed. They want to replead the dismissed claim. Do they file a new action? Is that how this is typically done, or is it never an option to amend the existing pleading to replead the claim that's been dismissed?
Our position is that it must be done the way it was done in the Myra business case. That is to say, you file a new action.
I'm just asking in common practice outside of Chapter 150.
Well,
claims are dismissed piecemeal all the time out of a multi-claim case.
Well, I mean, great question. What Cruz tells us is that when they're dismissed, and again, Cruz is good law. Take a look under tab 3. Any dismissal order stating that is without prejudice to refile, which could be under this statute, it could be under special exceptions, it could be under any number of things, refers to refiling in a new cause of action. If it's been dismissed, I mean, this is a decision 1994. Nobody's ever criticized it. And it's not simply filing an amended petition within the same cause. So it's not a rule of civil procedure. It is established practice, whether under this statute or in any other situation, to your point, in which there is a dismissal, you have to start afresh with a new pleading.
The statute says that it'll result in dismissal of the complaint. So suppose that Lehmberg's complaint had said, these guys are bad architects, and also they defamed me, and also gave me a loathsome social disease, and a bunch of other claims. And they don't attach the certificate with respect to the professional services to which it applies. Wouldn't that whole complaint have to be dismissed? Like, including the defamation claims? Because it says dismiss the complaint.
The answer is yes, it would have to be dismissed, because it's the complaint against a professional that includes an allegation that falls within the ambit of the statute. It would have to be dismissed.
Any further questions? Thank you, Mr. Alexander. Thank you to all counsel. The case is submitted, and the court will take a brief recess.